You may proceed.
Thank you. May it please the court, my name is Tom Lane. I represent the appellant Enterprise Rent-A-Car Company of Boston, Incorporated. In this action, Enterprise is seeking to enforce its statutory right of subrogation pursuant to Massachusetts General Laws, Chapter 90, Section 34M. Enterprise is seeking to enforce the plain language contained in the statute, which allows Enterprise to seek subrogation from another insurer of a liable party.
Aren't you seeking subrogation in essence from yourself?
No, we are not seeking subrogation from ourselves. We are seeking subrogation from the driver and his insurer. And the way the statute reads, any other insurance. And the language is very clear where it says any other insurance. Enterprise is self-insured with a bond.
Does that make a difference?
It does make a difference.
Why?
Because Enterprise is self-insured with a bond in the minimum statutory limit, which does not include guest passenger coverage.
So you wouldn't certainly be liable for bodily injury for guest passengers.
That's correct.
But you are for PIP.
We are for PIP, and we paid PIP.
Right. And you're the primary insurer for PIP.
We don't dispute that.
Yeah.
And that's why, as part of the statutory scheme, we immediately, pursuant to 90 Section 34M, evaluated the claims and paid the 3 PIP claim of the 3 passengers and the driver.
So you have the right of the passenger.
Yes.
Passenger can't sue the driver.
No, that is not correct. The passenger can sue the
For
driver.
PIP?
Not for PIP. The passenger has a right to bring his own claim against the driver for an injury.
Okay.
For an injury.
And if that were to happen, who would be the primary insurer?
Metropolitan would be the primary insurer.
For bodily injury.
For bodily injury.
But this is PIP. And you're the primary insurer for PIP.
We are the primary insurer to pay PIP, but the statute then allows us to pursue subrogation. There are 2 parts of the statute. One requires us to provide the primary insurance, which we did. We then have the right of subrogation. And the right of subrogation says any other insurer for a party that is liable.
It's the second part of 34M, right?
Yes, it is, Your Honor. Yes, it is.
Is there any other situation that you know of where you have two primary insurers, if you will? In other words, you've got the rental car, and then the driver has his own insurance, Metropolitan.
That's correct.
Is there another comparable situation like that where this issue comes up?
I don't see it coming up directly in the statutory scheme. And I do see it coming up on occasion where you have people in their employment capacity as to which insurance would kick in first, whether it would be the personal insurance or the
But doesn't PIP sort of have an exception for 152? If that's
It does. But as to the PIP, and we don't dispute that we are primary to PIP,
Yeah.
and that's why we paid PIP. But we then refer to the later part of the statute, and reading the plain language of that statute, we have the right. And where Metropolitan is another insurer, and it's not disputed, Metropolitan did insure the plaintiff here, and they do have guest passenger coverage.
But let's say you had bodily insurance as well.
We do have bodily insurance.
For the guest passenger.
No, not for the guest
Let's assume you do. So what happens then?
That would be a completely different situation.
Why?
Because we would be, as your question earlier, we would be in fact seeking subrogation from ourselves, because
Right.
we do provide that.
And I don't understand why you're not doing that now. I mean, this doesn't change the rules of subrogation, doesn't change the law of subrogation at all.
it's you're relying on the plain language of 34M, right?
Yes, we are. The plain language is the key issue here. And the statute, and obviously the court has seen there have been 2 Superior Court judges who have each interpreted it in different ways. Certainly from
Or
our
a
perspective.
third, Judge Whitehead is the one that you think is
Well,
terrific,
Judge
right?
Whitehead is the one I'm certainly relying on. And his decision went into deep detail. We're appealing Judge Spurlock's decision.
And Judge Gantz had reached the same.
No, Judge Gantz did not. That's a completely different situation.
Okay,
And I understand what the case, and let me just address that.
Sure.
Judge Gantz's case and Judge Kottmeyer's case both involved super escape clauses,
Okay.
where it was a unilateral creation inside a rental car company's or an insurer's document to unilaterally make themselves secondary. We aren't attempting to make ourselves secondary. We are relying on the statutory language, the plain language of the statute, which is different than relying on if we had created a super escape clause similar to Judge Gantz's situation, Judge Kottmeyer's situation. In both of those situations, it involved rental contracts where a super escape clause was inserted.
Going back to my first question, isn't this just like any other case where someone is driving someone else's car, they have insurance on their, as an operator of their own vehicle, and they're driving someone else's car with permission, they're guests in the car. Why isn't this just like that? There's an injury, the passengers are in, there's an accident, the passengers are injured, they get their PIP coverage from the insurer of the car.
That's correct.
And what do they then do? Do they then sue the driver?
They have the right to sue the driver if the driver has guest passenger coverage. And that's the position that we're in. We are in the position of the passenger.
So this should happen every day. It doesn't make a darn bit of difference that you're a rental company.
This is just a dispute
On the
between the insurers for whether you get repaid the PIP you
It's a
paid,
PIP
isn't it?
subrogation case.
Yeah.
That's it. And
Has
and
nothing
that-
to do with what rights the drivers have or the passengers have vis-a-vis each other.
beyond the point that we're in a subrogation position, that we're in their position. And I think that's an important theme as to the public policy here. We did not deny the innocent passenger coverage. Their claims were paid immediately. And then it then becomes, as part of the statute, subrogation, the equitable principle, and the legislature has determined that it should be done by looking at the principle of comparing what's involved. And again, it requires two things: any other insurance, which is in fact the case, and liability. It's not a situation where you can just willy-nilly go after another insurer. You need to be able to show that the driver was liable. In the facts of this case, our case, there was an intersection accident, and Arbella, that's why we had asked for arbitration, and have the arbitrator decide which party was liable for this accident.
So you're saying that this Section 34 changes all of the rules with respect to insurance?
I don't believe it changes all
Because
the rules.
there is a principal rule that the primary coverage for all things belongs to the insurer of the motor vehicle.
That is correct.
That is a basic understanding. This builds on that.
Well, it builds on it, but then also the legislature has created a subrogation carve-out. The legislature created the statute.
There's always subrogation, isn't there?
Well, there isn't straight in the bodily injury issue, and there's not a part of their policy, and the MAPE does not require a different. In the PIP statute, it specifically it has a full paragraph on subrogation that is not part of the other policies. Again, this is a situation where the legislature created this. It was statutorily required to allow the party to go after the liable party at that point.
Well, you could certainly go after the insurance company of the other operator if that person were at fault, right?
That's correct. That's correct. And we would have that option.
I still go back to the fact that you are basically primarily responsible as a matter of insurance law. Forget about 34M. 34M deals with the PIP part of it, but you are primarily responsible for the coverage.
We would not be for a bodily injury claim. If there was a bodily injury claim by the guest
I
passengers,
understand
we would
that.
not be covered.
I understand
primary
that,
for
but you're primarily covered. You're the primary cover for all claims on which you provide coverage.
That is correct.
So
That's
if there's an accident, it doesn't matter whether the driver's at fault because you're insuring the motor vehicle,
That is correct.
and you're the primary coverer.
Well, it doesn't matter as to the primary coverage, but it does matter as to the subrogation, which is a different principle inside the statute. If you read it the way you're
It
suggesting.
seems to me you're subrogating against yourself since you're primarily responsible for the coverage in the first instance.
We are not primarily responsible for guest passenger bodily
But
injury
this
coverage.
is not a claim of guest passenger bodily injury.
It is because we are in a position of seeking subrogation for the liability of the driver, which puts us in a position of there's no guest passenger coverage.
Are
If
you
we-
seeking subrogation of the PIP page of the driver as well?
No, we are not.
Just the guest passengers?
Just for the guest passengers. We don't have the right to seek it for the driver, because that would be seeking it from ourselves. We are in a position, again, as the passengers, seeking the guest passenger coverage. The cases, and again, as I had mentioned, Judge Whitehead's decision, look at the public policies that were involved, identical facts to the facts in this case. Again, Enterprise is self-insured with a bond. Metropolitan has their own policy beyond that. Identical facts, and in that case, Judge Whitehead emphasized that he was accepting the statutory scheme. And I think that's an important consideration in this case compared to the other cases that the Court has referred to. This is a statutory scheme. This is not anything that Enterprise created on its own. It's not attached to Enterprise's rental contract. It's a reading of Massachusetts General Law, Chapter 90, Section 34M. In that case, Justice Whitehead determined that OBI, similar to Metropolitan in this case, had the additional coverage, and the PIP would be allowed, the PIP subrogation would be allowed. We are not seeking
Lane,
PIP.
Mr. Lane, excuse me. Did Judge Spurlock have the benefit of Judge Whitehead's decision? I'm just trying to look at the
I
dates.
do not believe he did.
Because Judge Whitehead's came after.
Judge
Spurlock.
Whitehead's came after. I
He
think that's
relied
correct.
on Kottmeyer's,
Yeah.
Kottmeyer's decision.
He had a benefit of Kottmeyer's decision, and he also had a benefit of Gantz's decision. And again, I'm not disputing those decisions, but those deal with super escape clauses where the entity created those in the rental contract.
So you say they're different.
They're completely different. This is not a situation where Enterprise, on their rental contract, wrote a clause in that says we are not primary. In those conditions, and in those cases also, there's a much more higher public policy, because by not being primary, you're seeking to change all of the coverage over. This is for the limited purpose of PIP, and the PIP is capped at either $2,000 or $8,000, and it only is allowed to proceed in a case where there's liability, and in a case where, in addition to the liability, that there's other insurance
How
available.
much PIP did you actually pay? Do you
It's about
remember?
$16,000 in this case to the 3 passengers, and I believe that the Mr. Navis himself was paid about $6,000.
So that's the amount you're looking for.
That is the amount we are looking for.
So if you go to arbitration, you got to prove that the person, I think his name is Navis,
That's correct.
who rented your car was at fault.
Exactly. And that's what we had sought the court to enforce arbitration for, because the latter clause, the last sentence of the statute refers to that there's dispute between insurers, that should go to arbitration.
Is that an issue that should go to arbitration, whether the thing is arbitrable rather than coming here?
We have argued it is, but I frankly, I understand there's a legal issue that needs to be determined first. We are arguing.
Trader ordinarily wouldn't cover that legal issue?
We asserted that that was the case. Judge Spurlock disagreed with us at that
Are
point.
you still pressing that argument?
We are pressing it as part of our brief, but it's not my main argument here today before the court.
Could you recover if Mr. Navis is the driver?
Yes.
If he, or is it Mr. Fan?
Mr. Fan was the driver of the other vehicle. Actually, Mr. Fan was the owner of the other vehicle.
If you could also recover, though, in part from Arbella, if there, right?
Yes, and in fact, in this case, we asked for arbitration against both Arbella and Metropolitan for the arbitrator to determine which party is liable.
How could you recover from both?
We could not recover twice. The arbitrator needs to determine
Who's at fault?
Yeah.
who is at fault. Exactly.
Right.
And I'm not saying, but in order, it's typical to a pleading either or. From the facts of the accident, an intersection accident, where there's disputed, and just for the court's edification, Arbella also filed a claim against us, seeking for their passengers' damage.
Arbella hasn't filed a brief, have they?
Arbella is not taking a position on this case. There is a separate legal case that's being held in abeyance where Arbella sued Mr. Navis and Enterprise for their passengers' PIP coverage, which we are
So
defending.
Arbella is bound by the result in this case to the extent it affects the other case and affects them.
Exactly. And they have not taken a position either in the Superior Court, and they've never briefed anything up at the court where we are at this point.
So if you had, is it guest passenger bodily injury coverage,
Yes.
you wouldn't be here, right?
If Enterprise had that, yes,
Yeah.
that's correct. But
So you would be responsible for the PIP,
that is correct.
and you say that's the difference, because now you're not suing your own insured, in
That's
essence.
correct.
You're
That's
not
correct.
claiming against your own insured.
That's correct.
All right, so you got the passengers in this case. You step into their shoes. You have their rights.
Yes.
So their rights would have been to sue the driver, right? And the driver, if the driver got sued, would look to the insurer of the automobile, and you say, well, there's no coverage for guest bodily injury.
That's
So you'd
correct.
have to look to another insurer,
That's correct.
and you have another insurer.
In this case, we do, and in some cases, you don't. And in some cases, you don't have anyone to go after at that point. But that's the position we're in at that point. So. Thank you.
Thank you, Mr. Lane. Mr. Lyon?
Thank you. May it please the court, my name is Gregory Lyon, and I represent Metropolitan Property and Casualty Insurance Company.
The
decision of
statute read literally seems to say he's right.
Your Honor, it does say any other insurer, and that's really where the conflict in this case lies. If it is, read and interpreted literally, that would support, obviously, Enterprise's position. However, it's a direct conflict to the compulsory insurance statutory scheme, which would then relieve Enterprise of its financial burden of providing PIP to passengers in its vehicles. So it has the effect of subverting the compulsory scheme itself, and would relieve Enterprise of any obligations to provide the PIP.
Yeah, so anybody, any rental car company, Avis, Enterprise, so forth, Budget, they've got to provide PIP.
That's correct, Your Honor. And if they are allowed to pursue, virtually in every single case, either the
Driver.
personal insurer of its driver or another vehicle involved in the accident, they have been relieved of the obligations under the statute. And that's where the direct conflict in this case lies. Interestingly enough, in a case which I'll submit through a 16L letter, it's the Malhot versus Traveler Insurance Company. In that case, it was stated, in so large a legislative enterprise, there are likely to be casual overstatements and understatements, half answers, and gaps in the statutory provisions. I would suggest that this is one of those overstatements where they suggest that any insurer is going to be responsible ultimately for PIP. In this particular case, it is in such direct conflict to the other provisions that in order for there to be a harmonious interpretation.
Why is it such a conflict, though? I mean, as Mr. Lane says, they're not seeking the driver, right?
Well,
and they don't cover the passengers. So why is that such a direct conflict?
Well, the conflict is between the compulsory statutes, which require them to provide PIP to all of the passengers.
Which they did.
Which they did. Now, if they are allowed to subrogate in virtually every single case in which they do provide PIP to their passengers, then they are not actually sustaining their burden with regard to providing those.
Well,
PIP.
I take it that that's only if the driver, whoever, has a Massachusetts insurance policy, right?
That's correct. If they have Massachusetts insurance and it's optional, and they have optional coverage, there certainly can be a personal insurer who does not have optional coverage.
And since it's a rental car company, presumably there's a lot of times when it has nothing to do with a Massachusetts policy. The driver isn't from the state.
That's true. That's true. But there are most times in Massachusetts, rental cars are going to be rented by drivers from Massachusetts with their own vehicles, more times than not. I don't have empirical data on that, but I would suggest that that's probably the case. So virtually every time that someone has passengers in their car, Enterprise is going to be able to recover from somebody else and not suffer the risk of loss of their business operations. They're operating at for-profit, and they're seeking to shift the burdens of their doing business in some sense to the personal insurer of the renter of their vehicles. There's no place in the statute that says you have to provide PIP for passengers unless the driver of your vehicle happens to have personal optional bodily injury. Then it shifts back to the driver. It doesn't say that, and that's why there's the actual conflict between the compulsory scheme and this subrogation clause.
I may be missing something, but why is that any different than anything else?
Yeah.
I mean, I suppose I got collision on my vehicle and I have an accident, and my insurer pays me my collision, and then it says, well, we're going to get it back from the other guy. He was at fault. Would you argue that, they can't do that?
Oh, no, they certainly could do that. The difference here really is between who they're seeking it from, essentially. In that case, they're seeking it from a third party. Your insurer would be going after another driver. No. In this instance, your insurer is essentially going after you for different coverage that you have available. As if you had two different policies that were in effect while you were driving your car. They pay collision, and for some reason you had better collision coverage on some other policy, then they could go after that instead and be completely reimbursed. That's the problem here, is that to fully enforce this subrogation clause completely eliminates their responsibility to provide.
So they are, my brother said, suing their own insured, so to speak.
They are.
Mr. Navis.
They are, and it's an interesting problem because on one hand, they are the insurer of the driver of their vehicle for many different purposes, for compulsory bodily injury, as the two cases in Premier and Alamos upheld. They're the primary insurer for PIP to the driver. They're the primary insurer, in fact, for the passengers. But they're going to be relieved of that burden if they're allowed to subrogate against the personal insurer.
So for you to win here, we've got to rely on Malhot and say, well, we got the statute which on its face appears to cover this, but it can't be right.
I don't think you have to rely on it completely. I think that because if you look at the reading of the statute, it does say any other insurer. However, if you read the rest of it, it talks about coverage on a motor vehicle. It talks about approving tort liability and against another party who's, doesn't say another party, but an entity who's legally entitled to recover from that other party. It talks in general terms, it seems to me, if you read it.
Of other parties,
Of another party.
not your own insured.
It doesn't say specifically, even if they're insured by another insurer, or it's words to that effect. And that's why there is the arbitration clause in there. Obviously, the legislature didn't want there to be lawsuits between insurers trying to determine liability.
Do you look at any insurance treatises?
I did, Your Honor.
What do they say about this?
And there was nothing really particular with motor vehicle. The closest that it seems to suggest were in the landlord-tenant type of situations where the fire cases, where there's overlapping coverage and they're excluded, or they're included on the landlord's policy and the tenant also has insurance. And those really depended on the language of the insurance contracts themselves. There didn't seem to be anything that was particularly analogous that was here.
Is this the first time this has come up? I mean, there's been PIP's been around for a long time. Have these cases been going to arbitration?
They have, in particular settings. If this is a case where it's between two insurers, and this makes it a little bit different why there's actually even a lawsuit here, because Enterprise is not a member of the typical arbitration agreement that most Massachusetts insurers are a part of, that they agree to arbitrate all of these claims in the intercompany arbitration forums, usually handled by the claims adjusters. There's actually no lawsuit filed. But because Enterprise isn't a member of that group, that they have to file a lawsuit petition if there's no agreement apart and separate from that universal agreement. So most of the cases are handled and are never filed in court, but they're typically between two different vehicles and two different insurers. This is a unique situation that we have with Enterprise, and now since this first one is filed, it seemed to be a unique and novel argument made by Enterprise. There are many cases in the pipeline now, but those were the first cases that I had ever seen.
This is not a case, in your view, where the arbitrator should make the initial determination whether this statute, covers arbitration, requires arbitration?
No, it's not, Your Honor, because it really is a legal issue for the court. Because Metropolitan's position is that, well, we're not one of those insurers from which subrogation can be sought. So if, in fact, if that's true.
If you're not an insured, you can't go to arbitration.
That's correct. And even if we were to arbitrate that particular issue, we would always have the legal right to appeal that decision of the arbitrator and would be right back where we are. Because there's no other conflicting decisions on that point, that's why this case is before you today.
But can I get back to this for a moment? Is it relevant that Enterprise is a rental car company? Does the law change because of that, or what's the significance?
Not particularly, Your Honor. For instance, if it was a situation where someone was borrowing someone else's car.
Typical.
And there's nothing being paid between us. And the person is borrowing the car, and the person who borrows the car has the optional bodily injury, and the car that is being driven has just the compulsory limits, and there's no optional bodily injury for that car that's being driven. Well, then Mr. Lane is correct in that the bodily injury coverage would then come back to my insurance company to provide bodily injury coverage for injuries to the passengers in the event of an accident. So from that standpoint, it doesn't make any difference. But from a public policy standpoint, I would argue that it does. The difference being is that the person who rents the car is paying a fee to rent that vehicle. Again, Enterprise is operating a for-profit business, and the law requires them to provide basic statutory insurance. And one of those basic provisions is...
But you've given an illustration for bodily injury coverage. What about the person who borrows somebody else's car and has a passenger who's injured as a result of the negligence of the driver? How does the PIP work out?
The PIP is always going to be primary to the vehicle that's being driven. There's that would make no difference between a rental vehicle and the borrowing of the car. The case that was decided in opposite to Judge Spurlock's decision, the Sage Your case, they made it seems to me a big deal out of whether there was optional or not. In my opinion, that makes no difference for the purposes of PIP.
So Section 34M will operate in the totally private context, somebody borrowing somebody else's car, exactly the same way it'll work in this situation.
That's right. It certainly could. It certainly could. But the reasons for that would be a little bit different because, again, it's not an at-profit type of business. The person is not paying a fee. I think that makes it a little bit different. They're not going through a commercial insurer, which essentially Enterprise would be. It would still be equal between two personal insurers.
All right, let's go back to this example. Enterprise it's just an insurer. It's just an insurer. It's the same case, except it's not a rental car company. It's a friend's car. Same exact fact scenario. How does PIP get paid?
PIP would be paid by the person, the owner's insurer of that vehicle that was being driven.
And that insurer, would that insurer then have a right to subrogate and sue the insurer of the driver?
They very well may in that
To recover the PIP.
To recover the PIP.
Then why wouldn't they hear?
That's right.
Then why wouldn't they hear?
Oh, because for the very reason that I was stating earlier is that the Enterprise is essentially is the for-profit enterprise that's required to provide the PIP for these vehicles.
Is there anything in the statute that says for-profit enterprises don't take the benefit of this language?
No, Your Honor, but that's the public policy reasons that it was cited by the courts in the Alamo and the Premier decisions. Is that
You mean the ones about super escape clauses? Those ones?
That's right. Yes, because
do you think those are apposite here?
No, I think they do apply because essentially Enterprise is trying to have a super escape, if you will, because they're saying that we'll provide the PIP in the first instance, but we don't have to bear any financial risk for those purposes because it will always be recovered either by the third-party vehicle or the personal insurer of our renter.
But you said that, but that's the same situation as if it was a private insurer. Isn't that exactly what would happen? Didn't you just say that?
I did say that, Your Honor, yes.
And wouldn't it always depend on whether the driver happened to have, I mean, maybe all drivers do, but I don't know, optional coverage for
Bodily injury.
passengers?
It may, although because it's compulsory, the Enterprise must provide it, and that's the bottom. That's really what is at issue here. Is if they're allowed to subrogate every time, then they'll actually be providing no coverage at all. And it's further complicated by
But that happens in the private context, in the totally private context.
I don't know that it does. I don't know that it does.
Well, does Section 34M apply to all insurers equally?
I would think so. I would think so. But again,
Why do you say they're not providing any coverage?
They
are providing
did.
the coverage, and, you know, they may get it back in arbitration, they may not.
Well, I suppose that they're providing coverage in the sense that they paid it first. Although they're not, I think there's a difference
But
between.
it's not ironclad they're going to get it back. They may lose in arbitration.
They may, but they won't in this sense. In this particular case, where there's another vehicle that's identified as a potential tort vehicle that's insured by Arbella.
I mean, the guy that hit this car.
That's right.
Or vice versa, but they may lose against him, too.
In that sense, that's true.
That's
if
the
there was no
Arbella.
negligence.
That's the Arbella car.
If there was no negligence involved in this accident, then they wouldn't recover it. That's
Right.
true. But that's, again, a limited number of scenarios, I would suggest, they're either going to recover against Arbella or Metropolitan or the personal
But that's
insurer.
true in all subrogation cases. You've got a chance of winning or a chance of losing, based on who's found to be negligent.
Not necessarily, because in this case, they're more assured of victory or in being relieved of their obligations because there's no place else to point to.
But the main driver, they're not seeking it. I mean, so it's not like they're recovering everything. Even if they were to win the arbitration, there's still the driver they admit, this is our insured. We can't go after anybody for that PIP.
That's right, and they're admitting that their driver, was negligent, and that's part of the public policy problem with this case is that they're pursuing their own insured and must prove that their own insured is negligent. If they're not allowed to do this, they'll be, as stated in the Premier and the Alamo decisions, they'll be more careful about who they rent to and the condition of their vehicles. The question is whether or not Metropolitan was an insurer in this case for the purposes of PIP subrogation. A reading of the statutory provisions, consideration of the compulsory injury statute as a whole would lead to the conclusion that it was not. Thank you very much.
Thank you, Mr. Lyon.